Welcome to the Probate Nation. My name is Richard Ruddy, and I'm the host of the show this evening. People are living longer thanks to good health care and healthier lifestyles. But as we age, not everyone remains as sharp as they were earlier in their life. And frequently a loved one, a son or a daughter, is called upon to help an elderly parent or family member with both ongoing lifestyle and medical decisions. This help could be informal while they have capacity, or could be formal through a court appointment as the legal guardian of that senior when they no longer have that capacity. However, the preferred approach is through the use of a legal document called an Advance Directive for Healthcare. The Advance Directive is prepared and executed when your loved one has the capacity to do so. This document is very important to have in place as you age, and typically will forestall the need to bear the cost of court action to have someone appointed your legal guardian. Our show tonight digs more deeply into what is a healthcare directive, explores the types of authority granted to an agent, considers who should be your agent and should you name backup agents. Should your agent have authority to have you treated for mental illness issues, over your objection, and much more. With us are two elder law attorneys who will guide us through this discussion. Our first guest has been practicing law for 20 years, beginning in Paris, France, and since 2006 in Northern Virginia. She maintains her law practice in Vienna, Virginia, where she focuses on estate planning, estate administration, and elder law. She is certified by the Supreme Court of Virginia as guardian ad litem for incapacitated adults and receives GAL appointments in Fairfax County. She is past president of the Virginia chapter of the National Elder Law Academy as well. Our second guest maintains her law practice in Herndon, where she focuses her practice on elder law, guardianships, estate planning, and estate administration. She practiced law in Boston, Massachusetts for nearly 30 years before returning home to Northern Virginia in 2003. She is active in her community and serves on the board of directors of both the Herndon Rotary Club and the Arts Herndon. Please welcome Yanni Miorini and Peggy O'Reilly. Ladies, thanks for joining us.
Thanks for having us.
A lot of experience to be discussed up there with all that background. Goodness, great. And from Paris, France, no less. Welcome.
Yes, you will have my accent too.
And it's lovely. It's lovely. Well, let's begin, Yanni, and talk about, let's get right into what is an Advance Directive for Healthcare?
It's a document that you will sign in front of two witnesses where you're going to name an agent to be your advocate in front of doctors. It also has a second part that we will call a living will and also organ donation. In some states, the living will could be part of a separate document, but in Virginia, it's all combined.
Okay. And is an Advance Directive for Healthcare the same as an Advance Medical Directive or Healthcare Power of Attorney?
Yes, depending on which state you are living in, they have different names: healthcare proxy, healthcare power. We have like 5 to 7 names nationwide.
But they basically look to accomplish the same.
And they're exactly the same, yes, absolutely.
Okay. So Peggy, what is the purpose of a medical directive? Can you go into that in a little more detail?
Sure. The main purpose of the medical directive is to give you an opportunity to say, when you can, who you want to speak for you if you become unable to speak for yourself. Mm-hmm. So you designate someone who would understand what you need and what you would choose, mm-hmm. And someone who knows you and can talk to your medical providers. Mm-hmm. It's also an opportunity for you to say, specifically or generally, what kind of care you would like. So you give direction to your agent as well as to your medical providers.
And that's a very powerful tool in that document. So what happens if someone does not have this document in place?
Well, if you don't have a medical directive and you're competent, you're able to speak for yourself, then you advocate for your own medical wishes. Mm-hmm. If you don't have the capacity to do that, then Virginia law permits your medical providers to look to a series of people in order of priority. If you have a legal guardian, they're directed to listen to the guardian. Mm-hmm. If not, to your spouse, if you have a spouse who's living and has capacity. And then it goes in succession: adult children, parents, adult siblings, and so on. So that the providers are authorized to talk to those people if you don't have something in writing.
Mm-hmm. But that process tends to be a little more limiting than actually having a more detailed advance directive.
Well, you've given up the opportunity to give some direction mm-hmm. to your agent about what you would want.
Sure.
They're still supposed to make their best guess as to what choices you would make, but you haven't had the opportunity to actually say that in advance.
Okay. So Yanni, let's start to talk about some of the features of a medical directive. Who should be your agent?
Good question. Somebody you trust with your life. This person needs to be over the age of 18, but somebody that really you trust and will respect your wishes and understand them. And also somebody who can talk to the doctors. Because it's supposed to be an agent that is advocating for you and not somebody who will just take over power, but also being strong enough for imposing your wishes.
Mm-hmm. Okay. Now, in the case of medical directives, should somebody have a joint agent?
It's possible, but when you have two persons, you have to make sure that they're going to get along and they're not going to fight over the decisions. But yes, it's possible. Usually the doctors are going to talk to one or the other, so it's more like independent powers. Mm-hmm. Of course, you could write instruction that it will be joint powers, but I mean, we're talking with hospitals and they may just overlook quickly at the document, so be prepared that it's maybe just more like independent powers at the end, even if you write more instructions.
And now some people also will talk about having a successor agent rather than naming joint. So what is that?
I really recommend it because one person may not be available. As mentioned, however, is done by doctors. So when there is an emergency, they may just call the first person, and if they cannot reach the first person, they may go down the list. So whoever you name as your agent or successor agent, all of them, you must trust that they're going to do a good job.
And unlike the financial power of attorney, in the case of the healthcare directive, is it important to include contact information in your healthcare directive as to how to get a hold of these agents?
Absolutely. The two different ways the directive may be used is one, as Yanni has referenced, in an emergency situation. Mm-hmm. So you don't want to just include the address. You need to include a telephone number or where they can be texted, which is a more common method of communication, mm-hmm. Or an email address or both. So as many ways of contacting the person as possible, because your object is to maximize the chance that they'll reach the person that you've designated.
In the order in which you've
done
designated.
It, exactly.
Sure. Peggy, let's just continue. When do agents appointed have authority to act for you under the healthcare directive?
Generally, when you can't speak for yourself. So this means if you are unable to articulate your wishes or express them in any way, mm-hmm. If you are unable to appreciate the decision that needs to be made, or the consequences of choosing A over choosing B, mm-hmm. Then the agent would be empowered to act. Most documents will require that some doctor be involved in that determination, frequently two, who will say and willing to put in your chart that you can't make this decision yourself, and that's why they're listening to somebody else mm-hmm. to speak for you.
Okay. Yanni, what kind of authority is typically given to an agent in these healthcare powers of attorney?
A lot of power. They are going to make medical decisions for you, which medication, which treatment to go, and they may be able also to sign for hospital discharge, mm-hmm. find a rehab center, organize home care, whatever is necessary for your care. Mm-hmm. Although you can give them power to limit or control who is going to visit you at the bedside, but that needs to be included in the document. If not, they do not have that power.
Okay. Let's continue with that discussion, Yanni. There's things called protest directives.
Sure.
What's the context in which that arises?
They are also called Ulysses powers, because as Ulysses, then you're going to give an irrevocable power that you cannot undo. So they are really powerful document and needs to be signed in front of a doctor. So they have been, this law passed because family members of drug addict or a person suffering from mental disease, when they were on their medication or on the street, there was nothing to really help them. With this document, you are authorizing an individual, your agent, your advocate, to maybe against your protest at that time, put you in a psychiatric hospital for a maximum of 10 days and hoping that during these 10 days, then you're going to feel better and go back to the reality. You can, in addition, authorize forced medication and list the medication that you believe you will want to be forced to in that document. So it's very powerful, but it's really necessary for people who unfortunately may fall again into their addiction and be on the street. Finally, family have something so they cannot despair and see the person on the street anymore.
Now that is a document, though. The protection is that the doctor has to sign off on that.
Absolutely,
So that's a separate document from the healthcare directive that would otherwise would be prepared by an attorney.
Exactly, and it's limited for that specific illness. And yes, you will have to go to see your doctor to sign this document. Yes.
Okay, Peggy, let's talk a little bit about do not resuscitate and DNR instructions, and are these addressed in the directive?
They can be. A do not resuscitate order is a physician's order, so that neither you nor your attorney can give that order. You can authorize your agent, however, to consent to or not consent to a do not resuscitate order. So some thought about that, as well as other particular kinds of treatment, should go into your drafting of what kind of powers you want your agent to have. Frequently, it's the only question people think of when they think of doing their power of their medical directive. They want a DNR, they don't want a DNR. That's almost never the choice that needs to be made, but it certainly can be addressed in the medical directive.
I actually had someone come up to me at a seminar who told me about a person who had do not resuscitated tattooed on their body. And I explained to them that it's going to require a signature and involves a doctor's signature too, so I'm not sure that's going to work.
Right.
But
And a medallion or a bracelet, okay, but not a tattoo.
So that was an interesting one.
But that does bring up an interesting question, which is the DNR is generally a hospital order. If a person is resident in a nursing facility or at home and they don't want to be resuscitated and taken to the hospital, the emergency personnel don't have to read your advance directive and figure out what it says, because they're emergency people.
Right.
The state has developed what's called a durable do not resuscitate order, which again is a document you need from your physician. The lawyers don't have them. You have to get it from the doctor. That is a standard form which the emergency medical personnel will recognize.
And that's one that they would actually either on the
laminate it and stick it on your door.
Is it yellow? I think it's yellow, and they stick it on the door of the hospital room, or they stick it on the door of the home if they're coming through, so that the personnel
And
can
make sure
see
the
that,
EMTs will see
so
it.
they know that's in
Correct.
place.
Works better than a tattoo.
Yeah, that was interesting though. I didn't get a chance to view that tattoo, but I was told about it. Let's talk about how you create a medical directive, or healthcare power. Yanni, is a medical directive typically reduced to writing?
Usually it is. There's an exception that it can be oral, but only when you have a terminal condition that has been diagnosed. So yes, it is a written document.
Okay. And now, are there legal requirements as to the execution of the healthcare directive?
Yeah, you need to have it witnessed by 2 witnesses, and the witnesses need to sign. And I insist on that because often the free forms, people forget that it needs to be in front of 2 witnesses and signed by the witnesses. In other states, you have more rules. Like in Maryland, the agent cannot be the witness. The name agent cannot be the witness, or employees of rehab center, nursing home also cannot be witnesses of those advanced medical directives.
Okay. Do you guys recommend that it be notarized?
Cannot hurt.
I generally do it as part of a whole package of documents, some of which require notarization. There are some states that require notarization, so there's certainly no harm in having a notary sign with the witnesses so that you're sure that you're covered no matter where you go.
And in Virginia, they look for 2 witnesses.
2 witnesses.
But some states require 3. So you have to be careful as you walk that around. Peggy, tell me, when is a medical directive effective? Again, let's just make sure we get this straight. It's only effective when?
It goes into effect when you sign it. So those people are your agents as soon as you've signed the document. The agents get the authority to act only when a doctor or 2 doctors have determined that you can't make decisions for yourself.
So what should you do with your directive once it's been executed? So
Well,
you
you
enter
want-
your office and you sign it, and now you've got this power. This
Do
medical.
not put it in your lockbox. No one will see it, and it can't be used. You want to make sure that it will be found when it's needed. So it's a good idea to give a copy to your primary care provider. It's a good idea to make sure that your agents have copies in case of emergency. You want to make sure that your family knows where to find it if they don't have copies of it.
Sure.
You want to take it with you when you go to see a new doctor or go in for an elective procedure. And Virginia now has a registry where you can post your document online and get a wallet card that says, I have a document, here's where you can find it. And that's an excellent way to make sure that it will be located if it's needed. You put it right next to your health insurance card, because that's what the medical providers will look for. And it will tell the provider how to get access to your directive and know who your agent is and what you want.
Okay, excellent. And we talked about the, Yanni, a medical directive can be created orally, but only in a very limited instance.
Yes. If there is a terminal condition diagnosed, you will do your oral directive in front of your doctor and 2 witnesses. And what usually will happen, the doctor will write on your chart the instructions. So it actually is becoming written documents right there. But
Doesn't require signatures by you or by the agents,
Exactly.
or by the witnesses. He just makes the notation that they were there.
yes.
So we have some record about that. Well, let's turn to the thing that everybody loves to get when they turn on the internet and access the wide world of the web, and they go and look to find their forms, okay? And then talk about the danger of forms. Is there a Virginia statutory form for a healthcare directive?
Yes.
And
It's
is
a
that
short answer to your question.
And I know that some people say that that is a good form in and of itself, you know, because people recognize it and accept it, and it's a great place to start. Would you agree with that?
I think it is. The Virginia statutory form is modeled on one that was developed by the Virginia hospitals and is available on their website as well. So it covers all the necessary parts and will get you to think about the different kinds of things that you need to consider. If you want extraordinary treatment, if you want your agent to be able to consent to organ and tissue donation, anything that you have to say about your medical care, as well as designating the agent. And it has the proper signature, places, and instructions for how to do that.
Okay. Does this form cover all of the issues we discussed, do you think, Yanni?
Well, the issues are so big, it's covering the most important ones, but I highly recommend that to have this document really efficient, that you talk to your agent. And not just, hey, do you want to be my agent, which is already really important, and you should always ask whether the agent feels comfortable in being named agent. But also you need to talk to this person. Actually, the American Bar Association has a list of questions, and usually I'm giving that list of questions to my clients. Because if you do have a discussion, then your agent knows really what you want and understanding it, and therefore can fight for you. So you empower them. If not, they will do what they think will be good for you, but maybe not as much as what you want.
I recall a number of years ago, I actually went to a presentation that you actually put together in a way of a CLE about different types of advanced directives based upon religion.
Yes.
Okay, so is that something that people need to take into consideration as well?
Absolutely. I mean, if religion is important for you, yes, I did that research, and I sometimes do add a lot of paragraphs that will be tailored to your religion and some instructions, and it's available. Partly, if you come to see an attorney, you can really draft whatever is your wishes inside, and let's share that to your whole family. I mean, the same with organ donation. I mean, you can tell what you want to give and maybe what you don't want to give. The same with funeral instruction. Do you want to be cremated or not? I mean, that's a little bit outside, but if you say so, then people are not going to fight over what they think you want. So it's really important, yes.
And you need to be able to, of course, in the case of cremation, we need to be able to find that sooner rather than later before someone does something that they're not supposed to do.
Absolutely.
Well, let's talk about, we've covered a lot of material. There's a lot of different components to advanced healthcare directives. But I want to solicit from you some final comments, maybe some things you want to focus on for folks to consider as we close out this program. Peggy?
Sure. I would say that the two most important things are that everybody should have a medical directive. This is not something that you should wait until you're elderly to do. There's been a lot of court cases about the rights of the patient to make their own decision and who speaks for the patient if they can't. Most of those court cases, or many of those court cases, involve young women in their 20s, their early 20s, who didn't have a medical directive. Mm-hmm. So anybody who's over the age of 18 should have a directive so that they have an opportunity to designate their agent and make some expression about their wishes. Mm-hmm. The second most important thing, I think, is to make sure that the directive is going to be found when it's needed.
True.
So make it on record somewhere, make sure your agents have it, get a wallet card, something that will enable people to find it if they need it in an emergency.
Very true. Yanni, how about yourself? Some final thoughts or observations?
Like Peggy, I would say that everybody goes sometimes in their lifetime to a hospital, maybe for a few hours to longer. So therefore, everybody at some point will need help. Or may need help just as soon as you come out of an operation, you are druggy, and usually they want to talk to somebody to help you. So it's really important to have one. And I want to address that sometimes treatment and fast decisions needs to be done, and you don't want to have to wait for a procedure to be implemented, partly for stroke. The treatment right over is very, really important. Mm-hmm. So that will be my first. And second is, you don't want your family to fight about who think they know best for you. Therefore, organized. So therefore, again, you have a team, an active team, to help you when it's necessary.
Those are all good points. Mm-hmm. Well, I want to thank both you ladies for taking the time and talking to everybody here and to our viewers about the advanced healthcare directives. They're so critically important, and this has been valuable information that I think folks can definitely put to good use. So I want to thank you on behalf of ourselves and all the public service you provided to the citizens of Fairfax County.
Thank you.
Thank you for having me.
Thank you for us to bring that topic, which is really important.
You're very welcome. Advanced directives for healthcare, advanced medical directive, healthcare power of attorney, or whatever you wish to call it, the key point to take away from our program tonight is the importance of having one. This document is another critically important tool in planning for the incapacity of a loved one. Without it, will often require costly legal proceedings to get someone appointed your legal guardian. The healthcare directive is intended to empower your duly appointed agent to handle your care and medical decisions when you no longer have the capacity to do so. Drafting a healthcare directive requires careful consideration and discussion as to the breadth of the powers you wish to grant and to whom those powers should be given. There are many forms available, including the Virginia Advanced Directive for Healthcare and forms that a hospital may present to you on admission. However, you are encouraged to have a dialogue with an experienced attorney in advance without being under undue stress of an upcoming medical procedure, so they can compose a directive that reflects your wishes and your values. This is a great tool to manage your incapacity and a document recommended for all. This brings us to the conclusion of our show today on advanced directives for healthcare. Hope you found it informative, and remember that replays of the show can be viewed on the Probate Nation website. On behalf of the Probate Nation, thank you for visiting with us.